This lecture is on Module 13. As with my other previous online lectures class, remember nga this is a digested, condensed version sa kung ano ang ara sa module. You are still advised to read in the module in toto and also to research for any concepts pagid nga for clarity if hindi nyo maintindihan. The aim of this lecture is to make it easier for you. This is sort of a review, and this is also so that if hindi ta makaklase, considering the different unpredictable circumstances right now, you will still have a lecture nga this will guide you. However, again, it is still important for you to read up sa module, take down notes, and because this is very important considering nga lapit ng inyong midterms, and more importantly, lapit na kamo magawa sa inyong board exam. Okay, so let's start with module 12, which is about class, the burden of proof and burden of evidence. Ang objective after sini is mabalaan nyo kung ano ang difference between the burden of proof and the burden of evidence. Is also the objective of this lesson to explain kung sino ang may burden of proof sa criminal kag sa civil nga cases. Again, if you're still not aware, criminal and civil cases are different class, okay? Understand and classify presumptions and their evidentiary value and apply these concepts in situational cases involving evidence and presumption. So, in the next module, module 13, we will be discussing more sa mga presumptions. Pero for this module, amo ni siya nga aton nga objective. Okay. So, what's the difference, class, between the burden of proof and the burden of evidence? Sa burden of proof, class, the duty of a party is to present evidence on the facts in issue necessary to establish their claim or defense by the amount of evidence required by law. Again, ano ang duty sang party sa burden of proof? Mapresenta sila yasang ilang ebidensya based on the facts in issue. Okay, so ang ilang present nga evidence kung ano ang ginapa gusto nila pagaon to establish their claim or defense. Tandaan nyo, class, wala gini siya ga-shift during trial. Ang burden of proof, hindi na siya pwede nga, ikaw na ang plaintiff, ikaw naman subong defense, ikaw naman ang ma-prove. No, that doesn't happen. Wala ni siya gasaylo sang pwesto during trial. I don't know if you can understand me. Pero, may mga example na di karon. So anyway, this is also called the burden of persuasion or the risk of non-persuasion. Okay? Sino ni ang may responsibilidad sa burden of proof? Sa plaintiff, sa iya ang burden of proof para mapamatud-an niya ang iya cause of action. Kay defendant naman, to prove his affirmative defenses or counterclaims. Okay. General rule, he who would lose the case if no evidence is presented bears the burden of proof. Very simple ang giniklaso. Kung sino dira sa duwa ka party ang maperde kung wala siya sang ebidensya, but silingon siya na ang may burden of proof. In a criminal case, if ikaw tuya nga plaintiff ang naghambal nga ginsakit ka, pero wala ka sang witness nga mapakita ang ginsakit ka, wala ka sang medico-legal nga mapakita nga medical certificate nga may ara ka giman dira sang party sang lawas mo nga ginsakit ka, wala ka man mapakita nga picture nga may ara ka dira sang gagawa nga ebidensya, may mga bruises ka dira nga ginsakit ka. I'm talking about physical harm, class, not psychological harm. Then there is no evidence, maperte kasi mga kaso. And since ikaw sa duwa sa inyo nga party, may burden of proof nga magpagawa sina, then you would lose the case. Okay, balis karon ta na class. If may ebidensya ang plaintiff sang pagsakit niya sa imo, tapos ang next mo naman ikaw yang defense, ma-counterclaim ka, oo, ginsakit na siya, pero hindi ako ang nagsakit sa iya. Okay, so amo naman ang imo nga defense, ang imo nga counterclaim, no? So ang kinahanglan mo bilang ikaw ang gusto magpamatuod nga hindi ikaw ang nagsakit sa iya, kinahanglan mo may ebidensya kung sino gyud nagsakit sa iya. Pero kung wala ka na isang may mapagawa nga amo na nga ebidensya, then you would lose the case. Hence, you have the burden of proof to prove your defense or your counterclaim. I hope you understood that. Next, burden of evidence na kita. Ano naman niya ang burden of evidence? This is the burden of going forward. Diri naman niya class, ang duty or ang ulubraw na diri sang party is to present evidence sufficient to establish or rebut a fact in issue to make a prima facie case. Okay? This is the burden of evidence. It may shift from one party to another during the course of trial, depending on evidence presented. Once a prima facie case is made, the opposing party must produce evidence to rebut it. Okay. Let's now go to proof. It is the establishment of a requisite degree of belief in the mind of the trier of fact, which is in our case a judge, kaya wala man kita sang jury, regarding the fact in issue. Okay. The establishment of a requisite degree of belief. Okay. Gusto mo i-establish sang pagpati sa imo, amo na nga ginab for criminal cases, the degree of proof required is proof beyond reasonable doubt to convict a person. So kinahanglan mapruiba mo gid without a doubt nga siya gid yung naubra sang krimen. If there is a little doubt or a little belief lang gid sa mind sang judge nga hindi ikaw nag-ubra, then you may be acquitted. So that is your proof. Who has the burden in criminal cases? Okay, so dili na ta makitaan kung sino ang may burden sa criminal cases. Remember class, as you are part of the prosecution in a way, you have the burden of proof in criminal cases. Okay? May ara lang na sila sang certain instances nga baliskad. But the general rule is, in criminal cases, the prosecution has the following to prove. Okay? Kailangan ma-prove niya nga tanan nga elemento sang crime natabo. If it is homicide, was there intent to kill? Is there a dead body? Was there a positive identification of the accused? Okay? So, kung murder, dapat ara ang mga circumstances, qualifying circumstances. May ara bala sang treachery, premeditated bala ang murder. May ara bala sang four-armed man or band, ba? Nighttime, dwelling. Ano pa yun lang iban nga qualifying circumstances ng murder. Each element of the crime charge must be proven by the prosecution. Remember that class. That is why when you make your investigation, it's very important sa inyo nga mga police officers nga master nyo gid ang crime nga i-charge nyo. And I recommend nga memorize nyo gid ni siya klase mga elements. As you go along with your job, masapos na ni sa inyo, kaya usually gabalik-balik lang man aklas mo ang mga crimes nga usual kakatabo in your ang usual abis sa mga injuries abis is your serious injury, serious physical injury, less serious physical injury, slight physical injury. So memorize nyo lang na dira pila ka adlaw, no? And by now I think you should be memorizing that. And sa ano naman sa killing naman, you have your murder, ang pinaka seryoso kumbaga. Okay? And then You also have your homicide and then your parricide. So, tatlo na sila. If hindi iya nga tatay, nanay, iya nga bata, iya nga utod ang ginpatay niya, di out na ng parricide. Next ka na. Is it homicide or is it murder? Okay, so, dapat ma-check nyo gid class tanan-tanan ng elements. How about sa rape? Ay, paano na ginubra ang rape? Was it through sexual intercourse? Was it through sexual assault? May ara bala dira ang elements nga ang edad niya, kung pilang edad sang biktima, pila man ang edad sang nag-ubra sang krimen. So those are all very important elements and factors nga you need to consider each element of the crime charge. Okay? So sa inyo mo naman yung iba kung may estafa gid man na dira, then ano na siya nga paragraph sang estafa. As you go along, you will master man ang elements nga sina. Pero you have to really constantly study man for any changes or updates sa layi. Next, the prosecution must prove participation of each accused, okay, and conspiracy if alleged. Okay. Gusto mo pa gid i-prove nga aside from principal, may ara pa siya accomplice, then it is your duty as the prosecution to prove that. In the same way, kung ginahambal mo ya, si A kag si B, danay gina sila ya, si A ang gatawag sa akon nga, hambal niya, kaya ta ka mapasulod bala sa Coast Guard. Okay. Dayon, si B to, si A ga-transfer sang kwarta kay B. So, amo nang allege nila ang conspiracy. You also have to prove that. Next, aggravating or qualifying circumstances alleged in the information. Kaya mo na ginamba ko kahit na sa inyo ang qualifying circumstances, especially, for example, sa rape of a minor. That's already qualifying circumstance ang edad niya. Okay? How about in murder? If homicide lang, pero may ara sang treachery, nagamit siya pusil, nagkatalikod pa ang biktima, then you also have your qualifying circumstance. You also have to prove that, class. Okay? Civil liability, this also needs to be proven. O ginahambag niya sa estafa, amunin nga kantidad, ang ginpangayo niya sa akon 150,000, pero ang mapagawa niya lang nga resibo nga nabato niya is 20,000. So, you also have to prove that. How can you prove the civil liability? And it is the prosecution's burden to prove this. Meantime, ang accused, ano ya ang dapat i-prove sa accused? We have your non-liability. Affirmative or negative. Magkambaga affirmative, gina-deny niya nga, oops, I was not liable. Okay, or ang negative defense na gali, hindi ko na iya ang nagubra sina. Your affirmative, you can say nga, hambalo niya ni accused nga, ginubra ko ya ina. But, it was only because I was defending myself. Okay, that's your affirmative defense. Which is very hard sa tuod lang, class, ang self-defense. Lesser liability or mitigating circumstances. Hindi ako nangubra sina. Ginbuligan ko lang niya si A nga sakiton si B, pero lang ko to ya, sa ulihi ya, I changed my mind. Wala na ako, naghalin ako, so hindi kami in conspiracy with each other. That's an example of your lesser liability. Or your mitigating circumstance naman nga, yes, I did it, but I surrendered myself to the police officer within 24 hours. That's a mitigating circumstance, voluntary surrender. Okay. Presumption. These are your presumptions. Okay? Class, mga presumption. Ma'am, conclusive na siya, ma'am, ang presumption. So, it will depend, class. Okay? Mga mo sang presumption based sa facts nga gin-draw mo from another fact or group of facts, nakaubra ka sang isa ka conclusion. So, this may be based on human experience, logic, or law. That's your presumptions, class. Okay? For example, presumption mo, nagbuwa si A nga gisi na ang iya, ibabaw nga bayo, tsura niya sa buhok niya, gamo-gamo, tapos may mga scratches siya sa iya nga panit, and then gisi man ang iya nga skirt, and then ang next nga nagwa is si B. And si A, pagkakita niya kaibigan silinggitan siya nga, palayo ka sa akon, palayo sa akon, tabang, tabang. Based on that, you can make a presumption nga B did something to A which caused A to have that kind of reaction saan ka palapit si B sa iya. Okay? Because that is based on human logic experience. Makitaan mo na ito, may ginasakit nga tao, di ba? Or based on what you saw. So, in here, in presumption, it is very important to use your human experience if you were may empathy ka kumbaga, and also you use all your senses in assessing. Okay? So, amo ni budlay siguro if you're a police officer kag manhid kaya B, for example, wala kaya ka batsyag sang or wala kaya feelings or wala ka sang empathy. It's very hard because when you make an investigation, then of course you have to in some way have an idea of basic nga human experience. Okay. The types of presumption class, we have your legal presumption, presumption legis, and the presumption of fact, which is presumption hominis. Again, we will be discussing further ang mga disputable presumptions sa next nga module. Juris tantum, it may be rebutted by evidence. Juris et dehur or conclusive, hindi na siya makontradict sang evidence. May be statutory or constitutional. Presumption hominis or presumption of fact, deductions made by human reasoning or experience. Okay. Presumptions class do not replace evidence. They aid when evidence is lacking. Tandaan nyo na, hindi ni siya ang take the place of evidence. Once evidence exists, the presumption ceases. Kung may ebidensya kaya, hindi mo na magamit ang mga presumption kaya may ebidensya ka na. Okay? They relieve a party of the burden of proving a fact. In conflicting presumptions, kung may duwa ka lain-lain nga presumption, that with weightier reason prevails. And also, always remember, very important, constitutional presumptions prevail over statutory ones. Mas mataas kung sa level lang sang importance kung ano ang constitution, kung ano ang presumption sa constitution, mas ma-prevail ina siya sa layi ng iban. Okay? Because constitution is the fundamental law of the lands from which all other laws take their reference from. Okay? A presumption may shift the burden of proof to the opposing party. How about your conclusive presumption? Again, we will have more examples later on. Estoppel in pais, a person who by act or omission leads another to believe a fact and act upon it cannot later deny it. Estoppel against tenant. A tenant cannot deny the title of their landlord at the beginning of the tenancy. So, amo na yung mga estoppel, hindi mo na siya pwede makontest. Kaya conclusive na ni siya nga presumption. For example, baliabi ang garinta nga ako na niya ang balaya. Wala ko na diya garinta. However, may ara sila sang pinirmahan no contract of lease. You are stopped as a tenant to question or deny the title of your landlord considering nga may ara sang conclusive presumption nga since nagarenta ka lang, then you do not have the title over the property. Okay, that is an example. Okay. So situational or case questions sa the class, burden of proof. Okay. Si Juan kasuhan niya si Pedro for recovery of 50,000 pesos. Ang iya claim ginhulam na ni Pedro sa akon kag wala niya ko ginbaydan. Si Pedro gindinay niya nga hulam siya sang kwarta. Okay. Sa sini nga case class, sino ang may burden of proof? Okay. Again, si Juan naghulam kay Pedro sang 50. Naging kasuhan niya si Pedro. Uy, balik sa ko ng 50,000. Nga ginulam mo sa akon. Gindinay ni Pedro nga naghulam siya sang kwarta. Sa sini nga case, who has the burden of proof? In this case, who won? The plaintiff bears the burden of proof, since he would lose the case if no evidence were presented. Very clear. Okay? He has the burden of proof. Next question. In a murder trial, sa isa kuno ka murder nga trial, nagpresent ang prosecution sa mga witnesses, placing the accused at the crime scene. Ang hamba sa mga witness, gito yung akusado. The accused claims he was in another city at the time. Who has the burden of evidence now? Okay. So, if you look closely, ang claim niya sa prosecution is ditong accused. And they already presented witness, which means they have already presented their evidence. They have hindi man dispense, pero ang claim nila, nasuportahan nila sang ebidensya. However, si accused siya, may isa siya claim. And this is an alibi class. He's saying, wala ko tuya, I was in another city at that time. So this time, since it is the accused who was making that claim, then he has the burden to provide evidence ng iyang claim. Okay? Okay, here, the prosecution already established a prima facie case of guilt. The burden of evidence shifts to the accused to prove his alibi by clear and convincing evidence. Wait lang din class. May iyan ho lang ko. Okay, next we have may police officer nga nag-aresto sang isa ka tawo nga wala sang warrant. He claims the arrest was lawful as the suspect was caught in flagrante delito. Pwede ba sang court ma-presume ang regularity niya in the performance of duty? You will be facing this a lot as police officers. Most of the time, ang bugini ang defense ang police officer nga ginakasuhan sang base ang ilang ginaobra. There is a presumption regularity in the performance of duty sa aton nga mga civil service employees. Okay? So, in here, ginambal niya nga warrantless arrest. And legal to yung akon nga arrest kay ginalagas ko siya or he was caught in the act, in flagrante delito. Can the court presume regularity? Yes. There is a disputable. Tandaan nyo ni class ang disputable. Which means, pwede pa yung makapag-uwaya ang defense sang evidence to contradict this. Mga balon niya nga, dito yung regular ya, wala ako yung, I was not caught in the act. I was inside my home. The doors were closed. The windows were closed. I don't know how he could have gotten inside without a warrant. Okay, so that's a lawful man nga defense. That's since there is a disputable presumption, and if the accused presents an evidence of irregularity, then it will be presumed nga his duties were done regularly. Number 4, example naton sa conclusive presumption. Si tenant, muning ginamba ko kagina sa inyo nga example class, ginamba niya nga siya kung ano yung tag-iyas ang property nga ginarentahan niya. Valid ba lang yung claim? No. Why? A tenant cannot deny the title of the landlord at the beginning of the tenancy. This is a conclusive presumption, not just merely a disputable presumption. Okay. Sorry. So, these are your exercises, class, nga ibilin ko sa inyo. Sa burden of proof and burden of evidence. Which one shifts during trial? Okay. The burden of proof never shifts, class. Okay? while the burden of evidence may be shifted during trial, which can be rebutted by evidence. Okay. You answer this. Who is estopped and why? Estoppel in pais, estoppel against tenant. Here, estop diri siyempre si tenant. Okay? Proof, evidence, which refers to the persuasion of the mind versus material fact. Material fact, of course, is your proof. While evidence, this is the persuasion of the mind. Sakto ba? Okay? I'll leave that to you as an exercise. To answer on your own, you don't need, if you want to put it on your notes, then well and good. Okay. So these are true or false exercises. This time naman, I want you to write this on a piece of paper. This is a self-test, okay? And once you're done, you can check na lang sa answers ninyo based on this one. So, pause this video on this part to answer. I would highly recommend you to do that so that this is sort of a review for you na. So you can just pause this part. I'll give you time to pause before we go to the answer. Okay? So, first question. The burden of proof may shift from one. Answer ang taning karon kaso. This is the answer to the compare or contrast exercises. First question, the burden of proof never shifts. Only the burden of evidence may shift. So, first question, the burden of proof may shift from one party to another during trial. The answer is false. Number 2, presumptions can fully replace the need for evidence. Answer is false. Presumptions exist but cannot replace evidence. Tandaan nyo na ha. In criminal cases, the prosecution must prove guilt beyond reasonable doubt. Answer, true. The prosecution bears this burden. Fourth question, conclusive presumptions may be rebutted by sufficient evidence. Answer is false. They cannot be rebutted, class, when you say conclusive presumptions. Once a prima facie case is made, the burden of evidence shifts to the opposing party. Answer is true, because it is the burden of the opposing party to rebut. Again, class, the burden of proof is a duty to prove one's claim or defense, and it never shifts. The burden of evidence, meantime, it is the duty to present enough. For criminal cases, the burden of proof is always generally on the prosecution to prove that. Okay, and that never shifts. It will always be on the prosecution to prove that. Burden of evidence, it is the duty to present enough evidence to establish or rebut a fact, and this may shift during trial. Presumptions, these are logical or legal inferences about a fact based on another proven fact. Ang conclusive presumptions, class, hindi ni sila makontradict. Pero, ang disputable presumption, pwede na siya ma-rebut sa ebidensya. In criminal cases, the prosecution must prove the guilt beyond reasonable doubt, while the accused may prove affirmative defenses by clear and convincing evidence. So that is all for Module 12 before we proceed to Module 13.